Hello everyone, and welcome to this video tutorial in which we're going to be doing some revision for A-level law. And in this video we're going to be looking at the OCR sample question paper for lawmaking and the law of tort. And today we're just going to focus in on the 12-mark questions and look in particular at one question in detail, exactly what you would need to put in it on the topic of the literal rule. So I've switched my screen over now so that we're looking at the OCR A-level law, lawmaking and law of tort paper. This is the sample question paper that OCR provides. And on this particular exam, you would have 2 hours to answer a total of 5 questions, and the total marks are 80 on this paper. Now we're going to be focusing on section A, the 12 markers today, but I will scroll through the whole paper so that you can see the format of this exam. So in section A, you're being asked about the topic of lawmaking, and you have to answer 2 questions on section A. You're going to choose either question 1 or question 2, and then you're going to choose either question 3 or question 4. Notice that questions 1 and 2 are sort of explain or describe type questions which are worth 8 marks, and questions 3 and 4 you were asked to discuss advantages and disadvantages, and they're out of 12 marks. Come back to this section, but let's just see what else is on this paper. So on section B we get into the law of tort, and you have to choose either part 1 or part 2 on tort. So part 1, you've got a scenario question, and then you will have 220 markers based on the scenario, and then an essay that isn't based on the scenario but still on the law of tort. So that's part 1. So you could choose this one, but you've got a choice. So part 2, it's still on the law of tort, and the format is the same. You've got a scenario, 2 questions based on the scenario, and the essay question which isn't related to that but is still on tort. We won't look at these larger questions in this video. I will do some separate videos on my channel for these because they do require quite a bit of discussion, but we will just glance over the topics that you're being asked. So in part 1, you're being asked to advise some characters whether they're going to be successful in a claim of negligence, and also whether they'll be successful in a claim of occupier's liability. And the essay question is on whether vicarious liability is fair on employers. And you may have seen on my channel, I do have separate videos where I go through model answers to questions very similar to these, and I've actually done one for this very question, discuss the extent to which liability is fair on employers. So you might like to watch my separate video on that. Let's take a look at the part 2 option. So with part 2, again, you've got your scenarios here, but this time you're being asked on the law on private nuisance and the law in Rylands and Fletcher. And the essay question, you'll notice, is the same. You're being asked about vicarious liability. So you would choose either part 1 or part 2. So depending on whether you're more confident on negligence and occupier's liability or private nuisance and Rylands and Fletcher, that would be the decider for you on those larger questions. But we'll go back to section A because in this video I just wanted to look at some of the smaller questions on this paper, and specifically focusing in on one of the 12 markers and exactly what you would need to do to get a high score on that question. So on section A, you would either answer question 1 or question 2. Number 1's asking you about extrinsic aids to statutory interpretation. So in that answer, you'd be talking about things that are external to the Act of Parliament that may assist a judge in interpreting the Act. So you might talk about things like dictionaries and Hansard, other Acts of Parliament, reports by the Law Commission, etc. In this second alternative 8 marker, you're asked to describe the stages of the parliamentary lawmaking process. So for that, you would have to talk about all the stages that a bill goes through in order to become an Act of Parliament. And I do have some separate videos on my channel on that. But you'd be talking about the process of going through first reading, second reading, committee stage, report stage, all of that in the House of Commons, repeating it in the House of Lords before getting the royal assent. So they're very much descriptive type questions. Whereas the 12 markers, again, you just pick one or the other, are more evaluative. They're asking you to discuss advantages and disadvantages. And that's a higher level skill than just explaining and describing, hence why it's worth slightly more marks. Your options here are to discuss the advantages and disadvantages of the literal rule, and this is the one that we're going to focus on shortly in the video. Or the other option is to discuss the advantages and disadvantages of creating law using Acts of Parliament. So this one is asking you to consider what's the benefit of using Acts of Parliament rather than creating law through common law, through decisions in cases. That's the other way that we get law. So if you're talking about advantages of Acts of Parliament, you talk about the fact that it's respecting parliamentary sovereignty because it's a much more democratic approach to creating law than having unelected judges make it. The fact that it's written should hopefully mean that the law is more certain and more consistent, etc. And in terms of disadvantages, you could talk about the fact that Acts of Parliament can become outdated and maybe give some examples, such as the Offences Against the Person Act 1861, looking at the language there, such as grievous bodily harm, etc. The language is outdated, and acts like that struggle to cover brand new situations. So with that act, the Offences Against the Person Act, it was really designed to, in the days where people injured each other with swords, it wasn't designed to cover situations where defendants are deliberately giving each other HIV and infecting each other with diseases, which is what the law now struggles to have covered by that legislation. So that's quite a nice question, I think, there. But I wanted to zoom in and focus on this one, advantages and disadvantages of the literal rule. So I'm going to switch screens now to a PowerPoint so that I can talk you through the sorts of things you could talk about to get 12 marks on this literal rule question. I've switched over here. Obviously, you're being asked about the advantages and disadvantages of the rule, so that's what you need to focus on. But you should always start by defining whatever it is you're being asked about. So the literal rule is where judges give words their plain, ordinary, or literal meaning, even if the result is not very sensible. And it's nice to include a quote here from Lord Esher, and he famously said, "If the words of an act are clear, then you must follow them, even if they lead to a manifest absurdity." And now we're going to get into looking at the advantages and the disadvantages of this rule. I've been asked for advantages and disadvantages here, so it's important that you spend equal time discussing both. Don't just do loads of advantages and maybe, one disadvantage. You want to try and be balanced in your argument. Now, on my screen, I'm going to go through all the advantages and then all of the disadvantages. But of course, you don't need to structure your answer like that. You can give an advantage and then a disadvantage and then back to an advantage again. Structure it how you like. But for ease, I'm sort of putting them all together here on the screen. So the first major advantage of the literal rule is that it respects the sovereignty of Parliament, and it's preventing unelected judges from making law. And remember that judges are only supposed to apply the law, they're not supposed to make it, they're not elected. And if you think about sort of the socioeconomic background, the fact that they're mostly old white men, are these the people that we want necessarily going on a frolic of their own, making up the law? Possibly not. So it's respecting sovereignty of Parliament. Lord Scarman was in favour of the literal rule, and he explained that judges are, and this is a quote from him, to be governed not by Parliament's intentions, but by Parliament's enactments. And of course, that's another point that judges, when they say that they are interpreting the law, they will often say that they're following Parliament's intention, but they can't actually jump into Parliament's mind and know what Parliament was thinking necessarily. So the only thing that they can really be governed by is their enactments, by their words. It's also really important because the literal rule upholds separation of powers by restricting the role of the judge. We don't want the judge to have his finger in too many pies, as it were. We don't want him to be making the law and applying it. Okay, we only want him to be applying the law. So that we uphold this theory. And remember, it was Montesquieu that talked about separation of powers. The literal rule also makes the law more certain because the law is interpreted exactly how it's written. And when you studied this rule in class, once you knew the definition of the rule and you looked at some cases, such as Whiteley and Chappell, or such as the case of Berryman, you were probably able to predict quite quickly what the outcome of the case was going to be, because you're looking at the words. For example, from Berryman, they could get compensation if he was relaying or repairing the track. And once you realised he was actually maintaining the track, although it was harsh, it was easy to predict what the outcome was going to be. And that means if the law's more certain, it's easier to advise your clients on the likely outcome of a case. The rule is also easier for judges because if they're just following the words as they're written, they're not looking for the mischief, they're not digging away in Hansard and trying to find the purpose of acts. It's going to lead to quicker decisions. Disadvantages of the rule then. There can be disagreement as to what amounts to the ordinary or natural meaning of a word. So you'll know yourself that the meaning of words are not always clear. So the case of McGuinness was a case where the meaning of the word supply, although we would think that's has a pretty obvious meaning, there can be disagreement as to its ordinary or natural meaning. We also know that words may have more than one meaning, so the act can be unclear. And you could give some examples of different words that have alternative meanings. And of course, by using some case examples, you can talk about the fact that it can lead to unfair and absurd results. Obviously, Parliament didn't intend the outcome in Whiteley, and the decision in Berryman was very unfair because the whole purpose of the Act was to try and help unfortunate widows like Mrs. Berryman. Absurd decisions are clearly not what Parliament intended, and it undermines public confidence in the law. You know, people look at cases where words have been interpreted literally, and it seems daft, it seems absurd, it looks as though the law is a bit silly, really, in some respects. And the Law Commission famously made this remark: the literal rule assumes an unattainable perfection in draftsmanship. So the Law Commission are making the point that the literal rule is assuming that the people who are writing acts of Parliament can write everything perfectly so that everyone in the world will understand it, and it will cover every possible situation that comes up in the future, and there won't be any area for doubt. And of course, that's unattainable. Unattainable perfection is required for this rule to work. Lord Denning famously didn't like this rule, as we know. He preferred the purposive approach, and he said that if you apply the literal rule, the intention of Parliament could be destroyed, which undermines the law itself. And Zander describes the literal rule as mechanical, divorced from the realities of the use of language and from the aspirations of the human beings concerned. And in that sense, it's irresponsible. Okay, so I hope that video was helpful in helping you see what to include in that 12-mark question.